This is John Anthony Dumas versus Nico Battle. Mr. Dumas is here. He has filed written materials. Mr. Battle is also here. He has filed no written materials. The city of Everett is also here, represented by counsel. And I want to hear from them whether they take a position or not to make the record clear. All right, Mr. Dumas, you're the moving party.
Your Honor, we're all here. I filed an affidavit of elector for the 2025 primary race of Everett City Council District 4. It is my belief that the respondent, that he does not meet the requirements for being seated into the position. So that's why I filed, again, the affidavit. And I'm hoping to prove through all this that not only was he not eligible, but also that on December 9th, 2024, that he was actually a resident of the state of Georgia, which was about 10 months ago.
Please proceed.
Your Honor, if I may, before we proceed, I had a motion for the court today.
Did you file a written motion?
I don't have a written motion, just an oral pleading.
I would normally not accept that, sir. You have to follow the court rules.
Okay. You said you would normally not accept that. Would you be willing to make an exception?
No.
Okay.
I'm a big believer in the court rules. They're there to establish a certain policy, how the court is to determine justice, and if you don't follow those rules, there is no requirement, nor do I wish to take a motion without it. Go ahead, Mr. Dumas.
Okay, so out of the many, I filed a number of, per your Honor's instructions, to file evidence before the 6th of September. So I did file a number of declarations, and I'm just going to jump right into the declaration that I think is the most relevant in this case. And this was the declaration that I had done for voter data from the state of Georgia. In this, what I did is I used a public records request to request from the state of Georgia. It was for municipal district SC32 in Fulton County. On August 22nd, that request was fulfilled. And it showed that Nico Battle's voter registration is currently current in the state of Georgia, but in the data file, there is a heading that says the last contact date is listed as December 9th, 2024. And according to Tyrell B. Golden with the Secretary of State Election Divisions, he, quote, "The last contact date is the last date the voter interacted with our office. That may be in the form of submitting a voter registration or absentee application, updating their voter registration, or responding to a correspondence." So with that, I claim that that the respondent was a resident of the state of Georgia on December 9th, 2024. And then with that declaration, I had 4 exhibits. Exhibit 1 was the email communication that I put forth to the state of Georgia to make the request. Exhibit 2 is a summary from the data, because the data was this enormous data set that came through. So Exhibit 2 is a summary of that data, and Exhibit 3 was the email that from coordination with Georgia Secretary of State Election Division on the definition of last contact date. And then I did another open records request with Fulton County to see what the request was on December 9th, and the contents of that open records request is Exhibit 4.
Please continue.
Could the defense be provided with a copy of Exhibit 4, the contents of the supposed request made on December 9th?
Did you bring the copy?
I did, Your Honor.
Had a copy? Please continue.
So then just going through the, does Your Honor do you need a copy?
No, I have your materials.
Okay, you have one.
You submitted.
So again, I'll go through the exhibits. Exhibit 1 was $35 fee that I paid to request for the municipal data. Then I got the request for the voter list order on the email, and I will note that, what I got was a link for a Dropbox, which is active for 30 days, from August 22nd, that, this link is active. So anybody that has this link can go in and verify the data, and just pull that down, and then just query, put that into a spreadsheet, and query that for the respondents' information. And then Exhibit 2 is a summary of that information with highlighting of a registration date of 10/18/2023 and this date of last contact, 12/9/2024. And moving on to Exhibit 3, here is the email communication with Tyler Golden, NPA Constituent Support Specialist with the Georgia Secretary of State. And I highlighted again, the last contact date is last date that the voter interacted with our office. This may be in the form of submitting a voter registration or absentee registration, updating their voter registration, or responding to a correspondence. Registration records and their contents are maintained in the county elections office. You may reach out to the county registrar to receive additional details. Which then, the next exhibit, that's Exhibit 4 on that file. And this was just a summary of the information that Fulton County has on the respondent. And with that, that's, for that declaration, that was the, that's some of that declaration.
Please continue.
Okay. Again, I feel that this is the strongest evidence that the respondent was within, because there's two things that are going on here. The state of Washington says you must be a resident of the city for a year, and the city charter says you must be a resident of the district for the 6 months. And that date, seeing as the voter registration is still active, and that contact date was 10 months ago, so that places his residency, I believe, on that time with the state of Georgia. Moving on, I think that was that is the most of the argument. Next, I can go to the declaration of supporting RCW 29A. That's the main point of the affidavit of elector. And on August 14th, 2025, I contacted by email Patty Adams, the community manager at the Sage Apartments at 17.
You said the Sage Apartments?
Yes, the Sage Apartments.
Thank you, go ahead.
At Sage Apartments at 1730 112th Street Southwest, Everett, Washington, to verify the residency of Nico Battle. And Exhibit 1 is a true and correct copy of my correspondence confirming my communication with Patty Adams, where she stated that I have no record of this person living here, referring to the respondent. Then there was, the next day, a letter to the public came out, and I have that as Exhibit 2. It is August 15th, 2025, from Patty Adams, reaffirming her response and her conversation with the respondent. Attached as Exhibit 3 is public information from the website usaphonebook.com on Nico Battle, dated 8/17/2025. Exhibit 4 is public information from Spokeo, spokeo.com on Nico Battle, dated August 8th, 2025. And neither of those listed the 1730 address listed. Exhibit 5 is a public records request that went out to Snohomish County PUD, dated August 15th, 2025. Exhibit 6 is a return of service letter to Nico Battle mailed by a member of the community dated August 23rd, 2025. And Exhibit 7 is a copy of a search done in the Snohomish County Assessor Property Search on Nico Battle, showing that they own no property in Snohomish County currently. So again, Exhibit 1 is the email that I had sent to Patty Adams, Community Manager at the State Departments. I said, hi, there is a candidate for Everett City Council, District 4, who has listed State Departments at 1730 112th Street Southwest, Everett, Washington, 98204, as their residence. I am looking to verify if you have a record of any of one by the name of Nico E. Battle or Nicholas Battle on your property. And Patty responded on August 14th at 4:38 p.m. I have no record of this person living here. Moving on to Exhibit 2. This is a to whom it may concern letter dated August 15th, 2025. And Patty Adams goes in quite detail. If you're a renter anywhere, you know that most, if not all, rental agreements require that all persons on the premises are required to be on the lease. And part of what Patty goes on in this letter is they are they have to verify income of all people that are in the units, because they do have some, I believe it may be low income or fixed income housing units in the property. So because of that, some of those units are rent and income restricted. So that's why, another reason why that they must have everybody is on the lease. And then I'll read this final paragraph that she has listed in her letter. I contacted Nico Battle today in regard to getting an email, phone call, and visit about him, reporting that he lives here and or is staying with a resident at the State Departments. Nico reported that he will have to look into the unauthorized occupancy and a limited amount of time that a resident can have anyone staying with them without written consent from me. I asked Nico where he was staying, who he was staying with here. I offered to provide that resident with a copy of the lease agreement, and he declined to tell me. I asked Nico if he received mail at this address, and he responded, not really. I told Nico that it is a yes or no question. Nico said he would look into our unauthorized occupancy limits and said he did not feel that he was in violation of them. Again, signed by Patty Adams, manager at the State Departments. Moving on to Exhibit 3. This is a web report from usaphonebook.com, and the current address they have listed for Nico Battle was actually 1111 132nd Street, Southwest, Apartment C, Everett, Washington, 98204. Even though this is in the 98204 zip code, it is actually an unincorporated Snohomish County and lies outside of the boundaries of Everett City Council District 4. So that is, and these websites aggregate data from public sources. So also in that, it has a little redacted, but it does say workplace for Nico Battle, current senior partner. It starts IMP, Seattle, Washington, 98107, which I believe that is his business impact something or other. Apologize. Support. His education at Wake Forest University with a double major in communications and politics from 2019 to present is also in that file. Moving on to Exhibit 4. Exhibit 4 was from the website Spokio, and on a report dated 8/8/2025, and this is actually data that is out of Atlanta, Georgia. That's what came up. But there is an address here in Atlanta, 290 Cascade Rise Court, Southwest. And it said that was the residency from 2014 to 2024. I should also note that this is also the very same address that is listed on the respondent's voter registration in the state of Georgia. There is another address of note. There's one in California, but the one of note is actually 3907 Aurora Avenue, and that actually is listed from 2020 to 2024. And again, yeah, that's the one that is of note in Exhibit 4. Exhibit 5 is once again a public records request to Snohomish County PUD. And I filed that on August, well, they responded on August 15th. And the response to public records request number S000219-081225, Dear John Demas, the purpose of this letter is to acknowledge receipt of your request for public records received on 8/12/2025 at 10:57 p.m. to request clarification about the records you are requesting. You requested the following. Hi, I'm looking for utility bills going from November 2024 to June 2025 for Nicholas or Nico Battle at 1730 112th Street Southwest, Everett, Washington 98204, or Nicholas or Nico Battle at 111 132nd Street Southwest, Unit C, Everett, Washington 98204. We do not have a customer with this name in our system. Additionally, she put 1731, but I think she meant 1730. 112th Street Southwest is an apartment complex. If you would like us to provide information on a particular apartment, please provide a unit number. But again, please be advised, we do not have a customer with this name in our system. If you do, and then if they didn't hear from me by September 15th, then they will consider that closed. And this was Sarah D. Vittorio, Senior Counsel and Public Records Officer, General Counsel with Snohomish County PUD. Exhibit 6. So a member of the community sent a return service request letter addressed to Nico Battle at 1730 112th Street Southwest, Everett, Washington 98204. So that is a image of the letter, and I also do happen to have the letter itself in hand.
Okay, please continue.
Exhibit 7. Exhibit 7 is just a snapshot of just a search I did on the Snohomish County Assessor's website, recorded documents, and not finding any Nico Battle as owning any property in Snohomish County. And with that, that is the declaration that was supporting RCW 29A -08-810.
That conclude that question?
There are some other declarations that I did file. But honestly, I believe that those two are the most relevant, especially with the voter data from the state of Georgia. And I do believe everything that I submitted under declarations is relevant. It is true data, and it's material to this case.
So here's my question for you.
Yes, sir.
What evidence do you have as to his status as a registered voter in Everett, Washington?
That is the declaration of state of Washington voter data. So, the voter data in the state, the way that you approach it is it's a little bit more readily available but the data is only good, I think, for 48 hours to the link. There is a declaration that I filed, State of Washington voter data, that I did make a request on September 1st. And again, on that declaration, Exhibit 1 is the email requesting that data, and then Exhibit 2 is a summary, which I will just go ahead and jump to that. And here we have, again, this is right off of the data from September 1st for Nicholas Battle, and on it said that the address is 1730 112th Street, Southwest, Everett, Washington, 98204. No apartment listed. It lists the precinct code. His registration date is listed as May 7th, 2025, and last voted on 8/5/2025, and that status code is also as active.
So, last question.
Yes, sir.
So what is the status of the law on this? What do you need to show in order to demonstrate that Mr. Battle is ineligible to be a candidate?
So, what I believe the law says that it is the residency to meet the requirements of office, and for me, again, it is going back to the state of Georgia, to that last state of contact, because the voter registration there is still active. And if that last date of contact this past December, 10 months ago, if that was to say, hey, I'm moving, or I'm deactivating my registration for the state of Georgia, it would have, his current status in the state of Georgia would have been a non-active or deactive voter registration in the state of Georgia, but it is not. It is still active. So that means on that date, when he made that request, that it was that he was a resident of the state of Georgia on that date.
Anything further?
No, Your Honor.
Before I hear from Mr. Battle, does the city of Everett have anything they wish to add?
Not at this point, Your Honor.
Just to be clear, the law on this is as far as residency and voter registration is what? You can tell me.
Okay. State law, person has to be a resident of the city of Everett here for a year before the primary, and that date, that's then the December date that petitioner is talking about. With respect to the county or the city charter, though, it's 6 months before the primary that the person running has to be a resident of the district they're running for. And so in this case, the respondent would have to be a resident of District 4 for the 6 months before the August 5 primary. And that, doing your math, that's February 5.
Thank you. And the voter registration requirement is what? Is there one for that? I thought there was.
Yeah, that's the 1 year. The state is
1 year
is
prior.
the residency.
Yeah.
But that's not just for District 4.
That's for all the state.
Yeah.
Right.
Or also under the city, you can be just a city registered voter for that year.
Thank you.
Your Honor, if I may, the statute that council is referring to is 1 year prior to the general election, not the primary election, and that is a residency requirement. The state statute with regard to voter registration is that they are a registered voter at the time of filing. That is verifiable by just looking at the state statute.
You're right. He is correct on the day you start counting backwards from, being the general election for the year, and for the city charter, the city charter, it's from the primary date.
So what would be the date then?
For the primary date, that's the February 5, 2025 date.
Okay.
To be in District 4.
Thank you. Mr. Battle, this is your time to tell me anything you wish to tell me.
Absolutely, thank you, Your Honor. First and foremost, I want to, I understand that you had mentioned motions would have needed to be filed. In this case, I would urge you to reconsider only on the part that it would not have been able to be filed as evidence or as a motion in this matter, because the evidentiary date cutoff was September 6th. A hearing with the county auditor took place on September 8th. That was already 2 days after the evidentiary cutoff. My motion directly pertains to the hearing with the county auditor. With that being said, ultimately, what I'm asking the court, if the court is not inclined to dismiss this outright, given that there has been no judgment made by the auditor to revoke my voter registration, which is what Mr. Demas would need to prove here today in order for me to be essentially in order for me to be ineligible to run for this position, I move or would ask the court to grant a stay or continuance in this matter until after the Snohomish County Auditor issues a decision on the pending voter registration challenge, and such decision has had enough time to be entered into evidence in this matter. Washington law gives the auditor primary jurisdiction over voter registration disputes under RCW 29A.08.810 through 850. That process has not yet been completed. Proceeding here in Superior Court before the auditor has ruled. Oh, my apologies.
Can you start over with the RCW, please?
Yes, ma'am. Washington law gives the auditor primary jurisdiction over voter registration disputes under RCW 29A.08.810 through 850. That process has not yet been completed. Proceeding here in Superior Court before the auditor has ruled for inconsistent outcomes and effectively asked this court to decide on a question the legislator has assigned to the auditor in the first instance by virtue of weighing in on a question which will undeniably be aided by the auditor's decision one way or another. This is not just a clear benefit for judicial efficiency, but also fairness to allow both parties to incorporate the auditor's final decision into their arguments in this matter, vis-a-vis how best to proceed or whether or not proceeding at all is warranted in this matter. Such decisions like whether or not to have counsel present, whether or not to contest the petitioner's motions or motions, and whether or not dismissal may be more warranted in the future, rely heavily on this decision by the county auditor, since it is a question of, as you pointed out earlier, Your Honor, a question of my voter registration here in the city of Everett. A brief delay will cause no prejudice to the petitioner, but moving forward now, before the administrative process runs its course, would undermine both judicial economy, as I mentioned earlier, and the statutory framework, while causing significant prejudice to the respondent, in this case myself. So for those reasons, I would respectfully request that the court stay this matter pending the auditor's decision.
Thank you for the city of Everett before I proceed.
Okay, on that, first is just so you have the sites for the 1 year and the 6 month thing. It's City Charter, Article 2, 2.2 says, quote, "No person shall be eligible to hold elective office unless he or she shall have been a registered voter and resident of the city for a period of at least 1 year next preceding his or her election." So the way the calendar works out for that, the magic date there is November 4, 2024. On the 6 month part, the Everett Charter, Article 2, Section 2.2 says, quote, for council positions elected from council districts, he or she, so the candidate must be a resident of an applicable council district for a period of at least 6 months prior to the primary election date preceding his or her election. The magic date there would then be February 5 of 2025. Responding to the no prejudice, remember, and it's in the files, the auditor has to print the ballots. The auditor needs a decision on the 9th today because they have to go to the printer on the 10th. And so if this is stayed till later, the ballots that are going out might not be the right ballots. And remember that the reason the city takes no position on whether the petition, you should rule in the petitioner or respondent's favor. But the city does take a position that we want the election not to be subject to second guessing or like reversal or things like that because the wrong names were on the ballot. That's why we intervened, and we would like Your Honor to rule one way or the other so the ballots can be printed.
So I understand that the Supreme Court's already ruled on this issue, vesting me with jurisdiction in a case called Freud v. Hastings.
Right.
13 Washington Appellate 731, 1975. Would basically vest the jurisdiction of me regardless of what the administrative procedure is, because of the fact that there's urgency here.
Let's continue. Please continue, Mr. Battle.
Thank you. Is that your ruling on that request?
Yes, it is, sir.
Okay,
But
thank
please,
you.
it's not my ruling on the ultimate issue, but I want to hear that.
Absolutely. So first, I'm going to just kind of go over some of the evidence and exhibits presented by the plaintiff, and then we can move on to, I can respond a little bit more directly to some of that. Overall, this proceeding does not state a valid claim. It uses the wrong statute, and on its own exhibits, it confirms the registration in Washington is valid and active, especially given there has been no ruling by the county auditor to dispute that or to suggest otherwise. RCW 29A.68 is a narrow, extraordinary remedy meant to correct election officer error. It is not the vehicle for private disputes about housing or voter registration. Washington does have a separate and specific process for registration challenges under. Yes, ma'am. Under RCW 29A.08.810 through 850, which requires personal knowledge, presumes the registration is valid, and this lawsuit bypasses that entire process. Even if it is still able to be heard in this court today, Your Honor, you must then hold that the burden of proof here should be extraordinarily high to subvert these other procedures, especially in the event that should the auditor have found such urgency in this matter, or should the auditor have found the same evidence, which was presented yesterday in that hearing, to be so compelling as to potentially risk the integrity of the election, as is the city of Everett's concern here, they would have made a decision with said urgency. So rushing this through today for the sake of, for that sake, when the auditor is already, for the sake of the auditor, when they've already had a chance to hear it, does not make logical sense, Your Honor. Next, the evidence or the lack thereof. Let me briefly address some of these exhibits. Exhibits 1 and 2 or A and B, depending on which documents Mr. Bemis has submitted that you're looking at, which are the apartment manager's letters. Whether I was listed on a lease is irrelevant to the proceedings here at this court. Washington law does not require a lease or landlord permission to register to vote. Voters in hotels, shelters, or living with family are explicitly protected by statute. This non-traditional exemption applies to my case as well, given the transient nature of some of my work and some of my lifestyle, and does not require me to, and should not be a reason as to why I'm invalid to run for office here today. Exhibits C and D, the online phone book printouts, or I believe they have different numbers here. These are commercial data brokers full of disclaimers about inaccuracy. They do not rise to the level of accuracy that should be accepted here in court as evidence. They are not competent evidence of residency, do not override official voter registration records, especially without a decision from the auditor. Exhibit E, the PUD records request. This simply shows my name was not on a utility account. That proves nothing about residency. Many lawful voters live where utilities are in someone else's name. I've never claimed to have a utility account with Sonoma County PUD, nor again is this a requirement to register to vote or to be a resident in the state of Washington. Exhibits H and I, the Georgia and Washington voter data, which the petitioner has put the majority of his case on these files. These undercut the petitioner's case. The Georgia data shows that I last voted in March of 2024, not in November of 2024, which was before the December date of last contact. I did not vote in Georgia in November of 2024 because I did not live in Georgia in November of 2024. The Washington data shows that I registered in May of 2025 and voted here in August. There is no evidence of dual voting or no legal requirement that I personally reach out to Georgia to have those voter registration records canceled. It is common for those who move around a lot to at times be registered in 2 different places until one such jurisdiction drops a voter from their voter registration rolls. This is an automated process that secretaries of states across the country carry out routinely, as is done here in Washington. Another such example is King County, Washington did not remove me from the voter rolls there until December of 2024 as well. despite my not having participated in elections in King County since 2022 or perhaps 2021. So this isn't evidence of being a resident of the state of Georgia at the time. Rather, it's an evidence that at one point I had been a resident, and that point was in March when I did vote there and was working in a campaign there prior to leaving for Germany. Moreover, I do want to stay on the topic here a little bit because the plaintiff in this matter has routinely referenced Exhibit 4, this date of last contact. Going through Exhibit 4, and I brought this same point up yesterday, Your Honor, you'll see no communications from myself to the state of Georgia or to the county of Fulton County here. So Mr. Demas' open records request returned only a voter registration record, and said record supports the respondent's position here that I was, at the time of December of 2024, not living there, did not participate in the November elections, and in fact, the only election that I did participate in was in March of 2024 in Georgia. So respondents' claims that I have, in some sort of capacity, reached out to their office are currently unwarranted, and even their own public records request does not show any outreach on my part to this office. I myself am very curious. This is why I specifically asked for that exhibit, because I have no recollection of any outreach or even any response on my part to outreach that may have been done by them to confirm whether or not I still intended to participate in future elections, given that I had recently missed an election. What is most likely is that the state of Georgia or the county of Fulton County in some capacity tried to communicate with me regarding the fact that I did not participate in the November election in Georgia, and to see if I still wish to be registered to vote there. Unfortunately, that communication is unknown to me, as I was not living in Georgia at the time. I was living here and do not have the capacity to know what their outreach is. I would support any attempts to compel the Fulton County to provide whatever sort of outreach is being alleged here, but Mr. Demas' open records request does not show what he is claiming it shows here today, which is outreach from my behalf to the state of Georgia, confirming that I was supposedly a resident of Georgia at the time. Exhibits J through M, or again, I believe they have different numbers here, are just service papers in this lawsuit, not evidence of ineligibility. I've explicitly listed a mailing address and my voter registration as in accordance with Washington state law, as well as a campaign address for campaign-related mail, which is also in accordance with Washington state law, neither of which the plaintiff chose to use, and what I can only interpret as a brazen attempt at subverting our process here and an attempt to score a few points. Exhibit N, I believe is I don't know that the plaintiff has gone over that today in this hearing, but I believe it was submitted, but that was a PDC complaint which was entirely unrelated to this proceeding. Now, I go through all of these things, but at the end of the day, Washington law expressly protects voters in non-traditional housing situations. RCW 29A .08.112 says you cannot be disqualified for lacking a traditional residential address, which is a situation I've been in these times of transition. And in conclusion, this case is not a good faith application of election law. It is an attempt to weaponize the courts to remove a candidate from the ballot who has won overwhelmingly had a lead in the primary. This statute cited does not apply. The deadlines have not been met, and the evidence is either irrelevant, unreliable, or actually supports my eligibility. And, for those reasons, I ask that you would rule in favor of the respondent. But I'm going to go through, again, in the same sort of order that Mr. Demas went through, just to make sure that we're all clear. I did sort of keep better notes here of how he was labeling them today. So for the first declaration that Mr. Demas brought up today with the date of last contact, I believe I could talk about this ad nauseum, but I believe it's very important, Your Honor, that Mr. Demas is asking you to hang your hat here on this exhibit for your decision. Where in any of these documents does it show myself having contacted either the state or the Secretary of State in the state of Georgia or Fulton County's office? There's a line in a spreadsheet listed as December 9th, but even in Mr. Demas's open records request, he was not able to find any sort of communication between myself and them. Where is that communication? Would that not be a part of the record that was requested? What seems to me to be most likely, as I mentioned earlier, is that this was an attempt by the state or by the county to reach out to me, and not the other way around. And the email provided by Mr. Demas as to the definition of the date of last contact, there was no indication that this is an exhaustive list of what could be considered last contact. It is also likely that since these records are managed by the county, different counties may log things slightly differently within the state. The burden of proof here, and I know I'm just talking about different likelihoods, but the reason I'm talking about these likelihoods, Your Honor, is because the burden of proof here is on Mr. Demas to establish that there was meaningful contact, that it was not myself informing the state or the county that I did not live there anymore and had not lived there and would not be participating in future elections. But there was some other form of meaningful contact that took place on December 9th, or that I reached out to them, and he has not been able to meet that burden of proof. So assuming that there was this sort of meaningful contact, or that there was contact that would confirm myself as a resident or someone who wished to continue being registered to vote in the state of Georgia, is not sufficient. Mr. Demas has also pointed to the active status, saying that if I had reached out to let them know that I no longer lived in the state, that I would not be listed as active. As I mentioned earlier, most states have automatic processes by which they remove voters from their voter rolls. This aids in the efficiency of running their own elections, as well as ensuring that people's civil rights are protected and people are not arbitrarily withdrawn from voter rolls. Georgia is a state that is well known to have a process such as this, and so it is not at all unusual that I would still be registered there, given that there is no contestation that from the periods of towards the end of 2023, after my last semester at Wake Forest University, until May of 2024 or thereabouts, I was living and working on a campaign in Georgia prior to going to Germany. Now, beyond just that exhibit, there was Exhibit 2, just 1 second. Mr. Demas also presented information with regard to the state of Washington's voter registration database. This information, as I mentioned earlier, only supports my claim, and is a reason you should file for the respondent here. Mr. Demas has attempted to say that I'm not, or should not currently be a registered voter here in the state of Washington, but outside of any ruling from the auditor or any other evidence presented there. That registration, as Mr. Demas pointed out, is active and meets my qualification for being a registered voter. Now, moving on to Mr. Demas's declaration supporting RCW 29A, Exhibit 1, the August 14th contact between Mr. Demas and Ms. Adams, stating whether or not Ms. Adams had a record of me living there. It is obvious that in Ms. Adams' communication, she was referring to whether or not I am listed on a lease. I've talked already about today to this court that is not a requirement for being a registered voter at any location here in the state of Washington, and should not be seen as evidence to invalidate my candidacy in this race. I would like for you to cross-apply this same argument that I'm making to the PUD utility search and the property assessor's argument. So that would be Exhibit 5 and Exhibit 7 under Mr. Demas's declaration here. None of these things are requirements to be candidates. None of these things are requirements to be registered voters. These are, and ruling in favor of Mr. Demas without making that clear risk, rolling back the right to vote, right to run for office to only those who are well off, well housed, and have the financial resources to engage in those things, to engage in owning property, to be on their own leases, etc. Mr. Demas also submits another letter from Ms. Adams. This letter, while certainly interesting, is not a matter for this court. It is a question of a potential private dispute between the property manager and myself, and not about whether or not I'm eligible to be registered to vote, given my non-traditional living arrangement. Next, we will go to Exhibit 3. Exhibit 3 are the phone book records. Now, these start with the date of 2016, and by Mr. Demas' own confession, is aggregate data. Aggregate data does not rise to the level or the burden of proof set forth in Washington's code with regard to cases like this that must be highly probable. Aggregate data is often entirely inaccurate. It's based off of old public records, things that can be found online, and the data that Mr. Demas has submitted to this court in and of itself is riddled with inconsistencies. Mr. Demas alleges that I supposedly live in a location in Georgia, a location in Seattle, and in another location in unincorporated Snohomish County, all within the documents filed and mentioned today. These documents reflect previous addresses, perhaps, in most of these cases, but do not reflect my current address and are not proof that disqualify my current address, for lack of a better word there, Your Honor. The phone book records, most of them, their dates, they start with a certain date and then just don't end, despite different updates that may have happened in the interim. For example, as Mr. Demas pointed out, it starts with the date of 2016 and ends in, or it says it goes to be present for the address on 132nd Street, Southwest. I've never been registered to vote at this address. I've never voted at this address, whereas I have been registered to vote at a number of other addresses in Everett, in Keene County, yes, also in Georgia. I've voted there, been a PCO here in Everett prior as well. All of these things have happened since the time that I've lived at that address that are not reflected in this data, which I believe is just another reason as to why you should be very skeptical of the accuracy of this data and not willing to base your decision on these old phone book records. Now, moreover, the Spokio data that Mr. Demas says allegedly proves I live in Atlanta, Georgia, and or on Aurora Avenue out of Seattle suffers from the same inconsistencies and inaccuracies. So I don't believe there's any need for me to necessarily belabor the point there.
Just continue.
Okay. I don't believe there's any need for me to belabor the point there, but just simply say that I don't live at those addresses and that they are old addresses, and yes. Next is Exhibit 6, which was the return service letter. Now, I mentioned in my sort of statement earlier today that Mr. Demas had every opportunity to, or whatever member of the community that he's collaborating with had every opportunity to send whatever return service letter to the address that was listed as my mailing address on my voter registration, which is where I've opted to receive mail, or to my campaign address if it was campaign-related mail. The lack of accepting mail there, or mail being undeliverable there, is not a lack of living there, and is not evidence of such, especially when I have provided, and I've never claimed to accept mail at that address, and have provided mailing addresses for use. And then Exhibit 7, I've already mentioned earlier, which is just a property assessor search. Now, the third declaration is that Mr. Demas touched on, I believe, was more of the Washington State voter data, and a summary of the data. Is that correct, Mr. Demas? I don't have your third declaration here, so. Thank you, sir. Yes, sorry about that. So this third declaration was the Washington State voter data. As I mentioned briefly earlier, this should be seen as in favor of the respondent. All this does is prove that my voter registration is active, has been active for the duration of my candidacy, and it's not a reason to disqualify me from this race and to ignore the will of 42% of the people in my district who have voted for me in this race. At the end of the day, Your Honor, this is about allowing people in their district to choose their representatives instead of a few privileged individuals to try and disqualify candidates that have proven to resonate with their community through the legal process. This is, as I mentioned earlier, this is a weaponization of our legal process. That's why that there is manufactured urgency here. And instead of waiting for the county auditor's process that urgency was shared on behalf of the auditor's office, and they would have made a decision urgently. And so for the plaintiffs or either one of them to say that this is a matter of utmost urgency that must be decided today because of that and because of the auditor's office just does not follow any sort of logical sense. With that, I believe that covers everything.
Thank you. City wants to.
I would like to follow up on a statement that was made, and just to clarify things, with respect to the idea or the statement that the auditor already has had a chance to hear it and it's ruling on it. What the auditor was looking at is voter registration under state law. And what at least the city's part of what this issue is from the petitioner is candidate qualification under a city charter. It's a different it. And the city charter has you must reside within the district for 6 months. The purpose of that is to make sure the person running for that office is familiar with the district, knows the district, et cetera, et cetera. So it's a different it. Then with respect to the facts and the record, again, the city does not take a position as to whether petitioner or respondent should be ruled in favor of, but Your Honor is going to issue a ruling. We would like to make sure the facts in the record are clear because this issue may come up again, and the interest of the city is to make sure the record's clear. So I would ask either that you allow me to just ask some questions under oath, just establish what the facts are, one way or the other, of the respondent, or ask the court to ask some specific questions about detailing where he lived, for example, what he puts down on his IRS return and things like that as his residence address. Obviously, I prefer to ask the questions, but if Your Honor doesn't feel comfortable with that, I would request that Your Honor ask the respondent under oath questions just to make sure the record's clear on what you're ruling on.
Well, I'm not going to be attorney in this case. I'll let you ask questions. Mr. Battle, I'm going to ask you to raise your right hand, please.
Okay.
You swear affirm to tell the truth and nothing but the truth?
I do.
Thank you. Can you put your hand down? You may inquire, counsel.
Okay, and I'll try to be I've got a series of questions here, but first, Mr. Battle.
Is there any way I could be provided with these questions as well?
I'm not even provided with the questions, sir. He's going to ask questions as he thinks he needs to ask them, so I'll allow you to respond to every question he has.
Okay, I do feel as if this process is highly unusual for the third party to be granted that access. Is there a way that I could object to that? If the city of Everett has already sent out clarifications, clarification declarations, which I've already responded to, and I was not aware that they would be a party to this. So the preparations that have been made today are only in regard to the documents that Mr. Demas has submitted and the argument that Mr. Demas has put forward.
As I mentioned before, you filed no documents in response to Mr. Demas. We already had it pursuant to the statute, an order which allows the city to intervene. I'm going to allow the city to inquire as these basic questions, which may work one way or the other, because it's a which one I have to make.
Okay.
And just for asking for Mr. Battle, for your benefit, these are questions I've scribbled down as you and Mr. Demas were talking today. It's not something that's pre-prepared. And everyone in my family will confirm for you that my handwriting is totally illegible. First, Mr. Battle, where do you currently live?
I live with friends and family. My primary residence is with the Sage Apartments.
Right. Is there a particular unit you live in at Sage Apartments?
There is.
And what unit is that?
Due to the harassment that I've received on behalf of Mr. Demas and his colleagues, I'm not going to share that publicly. There's no requirement in Washington state law that requires me to do so. This is something that was discussed ad nauseum yesterday, and if there is a requirement to list a specific unit number on the voter registration, that is something the auditor has indicated he will make clear in his decision, which is again why I requested that the court stay this until after some time has been allowed. But since I'm staying with friends, and that's not the only place that I stay, I don't feel that is an appropriate thing for me to share.
In the 6 months before the August 5, 2025 primary, how many nights did you sleep in District 4?
That is a very nebulous question. I wouldn't have an answer to that exactly.
Can you give me your estimate?
I would venture to say many of them, majority of them, but I traveled extensively during that time, including during the time as a candidate. I traveled for a few weeks here and there. One such example is my capacity as a speech and debate coach and judge, but there are many other examples of my capacity as a consultant as well. So, which might I add is allowed under Washington state law. It's one of the exemptions. You cannot be disqualified from your residency or your voter registration status based on the fact that you travel for work. For example, when I first returned to Washington in September of 2024, I took a 3-month contract while I still returned home every week. The majority of those days I was out of state. That does not equate to me not being a resident or a registered voter here.
Okay, and I'm focusing on your residency, not your being a registered voter.
Exactly, and the same thing is there.
All right. Can you tell us how many days you were physically in District 4 in the 6 months before the primary?
Nearly every day. I would venture to say I don't have an exact number for you. As I mentioned extensively, I traveled at that point a lot more before I filed for office. I knew that I would have to make some sacrifices when I filed, and so I started traveling less, which has made my my situation even a little bit more transitional. But there's no exact number I can give you, but many of those days, if not most of those days.
Where do you receive your mail?
I've got multiple mailing addresses depending on the nature of the mail. The one listed for my voter registration, which I believe is most at hand for the issues that we're discussing today, is my father's address.
And is your father's address in District 4?
No, it is not.
Is it in the city of Everett?
No, it is not.
Do you file federal tax returns?
Yes.
And what's the residence you put on your federal tax returns?
There have been varied residences depending on the time that I'm filing my returns. I'm not sure about my most recent one. I have a tax preparer that works with my family and also handles mine, so I would need to confirm with them.
Okay, to the best of your knowledge, did you file on April 15?
To the best of my knowledge.
And is your testimony that you don't recall what residence you put down on your April 15 tax return?
I don't. As I mentioned to you already, I have work with a family tax preparer, and so those things are often handled in conjunction with my mother's tax returns, and I would need to check in.
Okay. How long have you been a registered voter of the city of Everett?
My registration, as I believe is public record, this most recent time is in May, but I've been a registered voter of the city of Everett for multiple years now over the course of my lifetime.
And that's the most specific answer you can give?
That is my answer, Counselor.
And how long have you been a resident of the city of Everett?
Again, same answer, multiple years over the course of my lifetime, most recently since I moved back to Washington in September.
And is it your testimony you've consistently lived in District 4 since September?
As I
Of
mentioned,
2024, sorry.
as far as residency, yes. As I mentioned, I've traveled extensively for work, including the most significant period of that being a 3-month contract out of state.
And when you say residency, just so we're clear, what do you mean by residency?
I mean, what is defined by Washington state law, we can look up. Yeah.
Well, you used the word residency, so my hopefully last question is, what do you mean when you say the word residency?
I mean, where my home is, where my community is, where I am most of the time, or where I consider myself to be from. I mean, where I have made my life and will continue to make my life. I mean, all of the things that are consistent with Washington State's interpretation of what residency is.
Okay, thank you.
Any further, Mr. Davis?
Nothing further, Your Honor.
Further, Mr. Bell?
Yes, Your Honor, I think that I just want to kind of summarize today's events and highlight what's really important, what's really at stake here. For the most part, Mr. Demas's case is a political weaponization of this process, Your Honor. There's been a number of documents submitted, but Your Honor, you really have to ask yourself, do these documents rise to the extraordinarily high standard of proof set forth in Washington state law to disqualify a candidate from running for public office, and by virtue to also disqualify their voter registration? Now, you said earlier that this Washington State Supreme Court has granted you jurisdiction in matters of urgency to essentially decide on one's voter registration, but then you have to also ask yourself, even if that jurisdiction is present, do you want to exercise that, given that there is an administrative process already underway, given that the auditor would have the ability to make a decision and correct the ballots in time for printing, should they deem that necessary? Given that your decision here, if it were not to keep the status quo and rule in favor of the respondent, would undo the will of 42% of the people of my community who have voted for me in the three-way primary to advance to the November general election. These are of extreme consequences and set a dangerous precedent that any one individual community who is dissatisfied with an election result, you'll note the three-way primary third place vote getter is here in the gallery today, that any one campaign candidate or their candidate's union buddy can file these processes, submit a number of contrived documents like old phone books and etc., and have a candidate who's duly won their election removed from a general election ballot. That is a dangerous precedent, Your Honor, and I ask you to take that very seriously. Outside of that, the notion here that my residency does not date back far enough is demonstrably disproven, and even though the burden of proof is on the plaintiffs to prove that my residency does not meet these qualifications, and not on me to prove that it does. As I mentioned before, I moved back from Germany in September, immediately came back to Washington. This was at the beginning of September. From there, took a contract, which, as you will know, Washington law does allow for residents and for registered voters to work out of state, to engage in other business practices out of state, even for extended durations, while still maintaining their residency and voter registration, Your Honor. So it is incredibly extreme, the relief that the plaintiff is asking for today, and I urge you to decide with the respondent in this matter.
This is not about the weaponization of the political process. This is not about whether someone has to own property to be a resident of the city of Everett, District 4. Nor does someone have to have anything but living in the city of Everett, District 4. That's the case law that's been brought down for over 50 years in the state of Washington. One must be a resident. Non-traditional housing has nothing to do with that. Number one, the law itself says any member of the electorate may bring a challenge to a candidate's qualifications for office. It doesn't talk about anything about motivation. That's because it is the policy of the state of Washington that our candidates live in the area from which they will represent their constituency. The constituency of Everett City Council District 4 requires a member of that district to represent them properly. That's what the statute says. And any elector who believes that the person who is a candidate is not a proper candidate has the right to challenge that, so that the process is clear, so that the elections are fair, so that the elections are not overturned because of issues of residency, which clearly, under the case law, means you must demonstrate that you've lived there. Mr. Battle, you have filed no documentation to refute anything that Mr. Demas has said. No declarations by anyone who lives with you, no statements to indicate that anything Mr. Demas has put in his declarations is suspect. Let me go over this. You just indicated that you stay with friends at the Sage Apartments. You live with friends. None of those friends have provided declarations in support of that statement. You haven't provided us with a library card that demonstrates your address. You haven't provided us with a driver's license. Any kind of ID card that would demonstrate that, other than the fact that your own statement that you're living with friends in the Sage Apartments, and that you also occasionally go out on business, which is fine with me. You have a right to do that. You will not say who the names of those people are. That's your right to do that. I'm not challenging your right to keep the anonymity of the people you say you live with. But you have to demonstrate the register once Mr. Demas has provided credible evidence that he has done so. The address at the Sage Apartments, 1731 12th Street Southwest Everett, has been refuted by the landlord property manager, who does not know you, never heard of you, hasn't seen you. Once that declaration was put in play, you had the obligation at least to refute that by showing what? Maybe there was a photograph of you. Maybe there's a piece of mail that you got there. Anything. You did none of that. There is no evidence, no lease agreement, and I understand you don't have to have one, but that's a factor. No utility bill, that's a factor. No phone bill. No, not any single record that links you to 1731 12th Street Southwest Everett, Washington. You travel a lot, that's fine. The number of days you may or may not stay there, we don't know. We have to take your word for it. You filed nothing that would demonstrate that you actually are a resident there. And the issue is residency, not voter registration. That's a component. Residency. Do I live in the place I say I live so I can represent the people I wish to represent? You list your father's address as your mailing address, and he does not live in Everett. You will not reveal the address, or you don't recall the address on your tax return. A simple reveal of the address on your tax return would have put some of this information in refutation. You didn't do that. Mr. Demas's records indicate that one address you've given in Everett is 111 132nd Southwest Apartment C, Everett, which is not in District 4. Now, he got that from online services of various types, phone book sites and so forth, so phone book records and so forth. But all of the accumulation of all those records, by the totality of the circumstance, demonstrates you don't have a residence in District 4. Your work business address is in Seattle. You have voted by your own, you have been a member of Seattle, the city of Seattle, for a while. The Georgia tracking demonstrates that at least as of December 2004, you were a voter in the state of Georgia. You claim to have come to the state of Washington in September of 2024. That's serious. You have not registered within the prior time. I don't see any evidence here that supports the claim that you are living in District 4, City of Everett. Therefore, I'm rendering judgment in favor of Mr. Demas. You have the right, of course, to seek appeal according to the court rules. I'll read the order of the court. I will leave an order to satisfy that. Does anyone have a written order? Mr. Demas, do you have an order?
I do not have a written order.
Tomorrow morning, I expect a written order regarding my decision. Please make sure Mr. Battle has a copy and the city of Everett has a copy. We will be in recess.